Trump gets a special master. It's the most beautiful special master anyone has ever seen. It's the most special, the most wonderful special master that has ever existed. He's not wrong. People have never seen a special master like this. But what does that all mean? Well, a Florida federal judge, Eileen Cannon, has temporarily halted the criminal investigators from reviewing the records found at Mar-a-Lago and ordered the appointment of a special master to check the government's work. However, the judge also allowed the government's intelligence damage assessment to continue. Many lawyers were quick to condemn the judge's ruling.
I think the driver on this from the beginning was loads of classified information sitting in Mar-a-Lago. People say this was unprecedented. Well, it's also unprecedented for a president to take all this classified information and put him in a country club.
Are they right to be upset? Well, before we set our hair on fire, let's look at how we got here and then consider what the judge ruled and why. And of course, why the DOJ is going to appeal that order to the 11th Circuit and what that means. Now, all this got off to a strange start when Trump's lawyers didn't file this motion in the court that had created the search warrant in the first place. Instead, they created a new case, a civil case, and that landed in front of federal judge Eileen Cannon, who we'll talk about in a moment. Now, in the DOJ's brief in opposition to an appointment of a special master, it outlined new details about the classified documents that Trump had taken from the White House. First, it included a photograph of the materials displayed on the floor of Mar-a-Lago. The photo shows 5 yellow folders marked top secret and a red one labeled secret lying on the ground beside a box of magazine covers. Now, the photo is pretty standard procedure by law enforcement. They normally document the things that they have seized. Now, Trump and his lawyers were outraged by the photo, which they say merely shows that Trump was in possession of his own records. But also, their response did not address one of the key claims that Trump supporters continue to make, that Trump declassified everything in their possession. So far, the lawyers have not bothered to make this argument in front of a court. But Donald Trump was very offended by this photograph for other reasons. He called up a conservative radio show to rant about how sloppy the FBI was with the records. He claimed he kept them in a much neater fashion.
But I had confidential documents spread out all over my floor. And like a slob.
Trump's family members also emphasized the former president was a neat freak. Quote, he's a very neat individual. He would never scatter documents around on a floor like that. But none of this is about whether Trump is a slob. The issue is whether Trump had possession of documents that he was not allowed to possess in a completely unsecured location. Trump's comments could also be viewed as an admission that those records were not planted by the FBI, which is contrary to some of the other messaging that the Trump camp has been doing. The Justice Department's filing also pushed back on Trump's claim that he'd been cooperating with the government all along. The DOJ said that when they arrived at Mar-a-Lago on June 3rd, one of Trump's lawyers handed over a single red-welled envelope, double wrapped in tape. The lawyers said that the records inside had come from a storage room. Another lawyer, probably Christina Bobb, signed a certification letter swearing under oath that a diligent search had been conducted and that all the classified materials on the property had been turned over, or all the documents that had been labeled as classified. Side note, Alina Habba and Christina Bobb, Trump's lawyers, have given several interviews where they potentially incriminated themselves as witnesses or targets of the criminal investigation.
Sorry to interrupt, but was there a limited number of people who had access to that storage room? It seems like a pretty important room, right, since they've made such a big deal of it and have the lock on it and so forth. So were there a limited number of people who could go in and out?
Yes, absolutely.
Or have access to
certainly
it?
Mar-a-Lago is secure in and of itself. You know, just getting onto the compound is hard. And then it was a locked door, and getting, back down into the basement, there's security. You can't just walk down there. Only certain members of staff can get there, and then there's only one key.
They found these 3 mundane statutes: espionage and the 2 others, obstruction.
Habba told Charlie Kirk that on May 5th, 2022, she searched all desks, drawers, nightstands, dressers, closets, etc., with explicit permission from Trump in an effort to track down documents related to a subpoena from New York Attorney General Letitia James's investigation into the Trump organization. And although the New York investigation is a separate matter, Habba placed herself at the scene of the potential crime. And when the Justice Department delegation asked to see the storage room, a lawyer for Trump explicitly prohibited them from opening or looking into any of the other boxes inside. The government asserted that this stopped them from confirming that no materials with classification markings had been left behind. Investigators then discovered evidence that there were still classified documents at Mar-a-Lago, and this probably came from witness interviews. And after further investigation, the DOJ team said it had reason to believe that government records had likely been, quote, concealed and removed from the storage room, and that efforts may have been taken to, quote, obstruct the government's investigation. Then the government decided to apply for a search warrant. In the filing, the government said that when they went inside Mar-a-Lago, agents found more than twice the number of classified documents that Trump's lawyers had handed over before when they allegedly had made their diligent search back in June, including 3 that were found not in the storage room, but in desks in the former president's office. Now, the DOJ's brief also included 2 grand jury subpoenas. The first subpoena asked Trump to turn over the documents at Mar-a-Lago, and the second was for footage from surveillance cameras. Mar-a-Lago footage would be used to track the movement of the materials within the club. Now, I'm largely going to skip over the Trump reply brief in response to the DOJ's opposition. It's less of a legal document and more of just a public relations attempt. It really doesn't address any of the things that the judge wanted them to address. It fails to rebut any of the arguments that the DOJ has put forward. And similarly, as we covered before, the judge teed up exactly the issues that she wanted the Trump team to address, and they failed to address those issues in either the moving papers for the special master or in the reply brief. Effectively, their papers were just placeholders, just getting something in front of the judge. Though, as we now know, that's all they needed to do. As I alluded to earlier, the judge has now ruled in Trump's favor on the motion to appoint a special master. The order appointing a special master was issued by District Court Judge Eileen Cannon, who, it's important to note, was nominated by Trump to the bench in 2020. Judge Cannon was confirmed by the Senate by a vote of 56 to 21, just days after Trump lost the November 2020 election. So first things first, is it kosher for a judge to rule on a criminal matter involving the president who appointed them? Well, there's absolutely no law saying that they can't. Generally, it's not a conflict of interest for judges to rule on matters involving the president who appointed them. This happens fairly regularly. But that typically comes up in the context of laws that the president enacts or executive orders that they issue, not in actual criminal matters that concern that particular president. All right, so with that out of the way, let's look at what the judge actually did. The first issue is the judge's order on Rule 41G. Trump filed a motion seeking the return of privileged materials and property under Federal Rule of Criminal Procedure 41G. That rule allows a person, quote, aggrieved by an unlawful search and seizure of property or by the deprivation of property to move for the property's return. Now, since there's no pending criminal case, Trump filed a motion as a plaintiff in a civil case. That means he was trying to initiate an action in the pre-indictment stage. Now, in the case of Ritchie versus Smith, the Fifth Circuit Court of Appeals developed a 4-part test to determine whether the government must return property in a pre-indictment case. First, whether the motion for return of property accurately alleges the government agents displayed a callous disregard for the rights of the plaintiff. Second, whether the plaintiff has an individual interest in and need for the material whose return he seeks. Third, whether the plaintiff would be irreparably injured by the denial of the return of the property. And fourth, whether the plaintiff has an adequate remedy at law for the redress of his grievance. Now, the rationale of the Ritchie case is that the government should not be allowed to seize and retain privileged documents in a pre-indictment setting. However, quote, in order for an owner of property to invoke Rule 41G, he must show that he had a possessory interest in the property seized by the government. Now, the DOJ had argued that Trump cannot show he had a right to the records that were seized, citing the Presidential Records Act, which says that presidential records are owned by the United States, not by the former president. And during oral argument on the motion, the judge asked Trump's lawyer to address the second and third Ritchie factors. Lawyer Jim Trusty, Trump's lawyer, replied that the entire dispute was akin to an argument over overdue library books. Now, the judge described Trump's motion as, quote, somewhat convoluted, but concluded that, quote, this filing is procedurally permissible and creates an action in equity, though there has been a lot of pushback about the court's jurisdiction in this particular case. And in assessing the Ritchie factors, the judge said that the DOJ did not display a callous disregard for Trump's rights. So the government came out ahead on the first factor, but it was all downhill from there. As to the second factor, whether Trump has an individual interest in and need for the material seized, the judge said that this factor cut in Trump's favor since the DOJ, by its own admission, had seized Trump's medical records, correspondence related to taxes, and financial information. Judge Cannon says that this amounts to over 500 pages of documents. However, the government seized over 11,000 documents, which means that the subset of documents that belongs to Trump amounts to less than 5% of the records seized under the warrant. The DOJ argued that the mixing of these personal items with other documents is evidence of a crime and can have evidentiary value in and of itself. If Trump stored his personal records with classified materials and Post-it notes, It could suggest something about his mens rea, his mental state, for what he was doing with these classified or protected documents. Now, Judge Cannon is a former federal prosecutor, and she agreed that the Justice Department's concern was valid, but she said that Trump's interest was stronger. And the third factor is irreparable harm. To show irreparable harm, a plaintiff needs to demonstrate that there would be no remedy for the damage that the government inflicted. The judge concluded that a special master was necessary to stop harm to Trump's reputation. Leaks to the press could be harmful to Trump, and the judge concluded, with no analysis, that the government leaked stories to the press, although the government obviously denied this, and she seemed to ignore the fact that it was former President Trump who was providing almost all of the information to the press when these things happened in real time. Now, Judge Cannon said that Trump could be irreparably harmed because of the stigma of potential criminal prosecution. Quote, frequently the public remembers the accusation and still suspects guilt even after an acquittal. Though, as many criminal defense lawyers have pointed out, including Renato Mariotti, Mark Zaid, and Sarah Azari, all defendants suffer reputational damage when they are indicted. Not just this former president. These lawyers also said that they were looking forward to citing this case on behalf of their clients. And yes, it would be good for criminal defendants if they could have a special master to review evidence seized from them in the pre-indictment stage in all criminal cases. And they would have a much better chance of avoiding criminal indictment if they could identify the government's witnesses and knew what the government was thinking beforehand. And that's one of the reasons why the DOJ opposed Trump's motion for a special master. But national security lawyer Bradley Moss thinks that it won't help most criminal defendants because the judge wrote this to help Trump and Trump only. Now, in her order, Judge Cannon seems to confirm Moss's conclusion that the rules are different in this particular case. Quote, as a function of plaintiff's former position as president of the United States, the stigma associated with the subject's seizure is in a league of its own. And Judge Cannon came up with another reason why Trump might suffer irreparable harm. Quote, a future indictment based to any degree on property that ought to be returned would result in reputational harm of a decidedly different order of magnitude. Of course, we aren't there yet. Trump has not been indicted, much less indicted because of personal property that the FBI had no right to seize. And as many have pointed out, often you are allowed to seize documents that are intermingled with the documents that are explicitly mentioned in a search warrant. But the judge suggests that Trump wouldn't have any remedy or any defense if he was indicted based on material the government should not have seized. But that's incorrect. If Trump is indicted using evidence that the government should not have taken, his lawyers would file a motion to suppress the evidence. But Judge Cannon heads this off and argues that a special master can prevent this from happening by checking the government's work in the first place. Now, all of this seems to contradict the judge's same decision to allow the intelligence community through the ODNI to continue its review of the evidence while the criminal investigation has to stop. Here, the ODNI is doing its damage assessment to find out who had access to the sensitive information in the documents and whether national security interests were compromised. And I suppose someone could argue that the criminal investigation into Trump's records would harm his reputation while the intelligence community investigation would not, but that seems incredibly dubious, not to mention it's all part of the same executive branch, which many have argued is a unitary executive branch. And on top of that, the intelligence review could lead to further criminal charges. Moreover, some people have already concluded that Trump put human intelligence sources at risk. That conclusion, if it's mistaken, would seem to be just as serious as the stigma that attaches to a criminal investigation itself. Now, the DOJ filed an extensive brief explaining how its filter team separates personal items and attorney-client privileged records from everything else that the DOJ sees. The judge was unmoved by their arguments, however. She held that Trump met the 4 Ritchie factors. The judge said that rating the ex-president without a third-party reviewer just doesn't look good. Quote, the government's argument that another round of initial screening is unnecessary also disregards the value added by an outside reviewer in terms of, at a minimum, the appearance of fairness. Even if the DOJ filter review teams often pass procedural muster, they're not always perceived to be as impartial as special masters. And that takes us to the judge's analysis of the executive privilege issue, which is, to put it mildly, convoluted. Judge Cannon says the government made a mistake by not screening the records for executive privilege. Now, this overlooks the fact that the Justice Department is part of the executive branch and that President Biden holds the executive privilege now and has already delegated his authority to NARA, which says none of these documents can be protected by Trump under the guise of executive privilege. But this order hints that this is really a dispute between former President Trump and current President Biden. The Supreme Court's precedent says that executive privilege almost under every circumstance stays with the office of the current president. It's theoretically possible under the Nixon versus GSA case for a former president to have some tiny sliver of executive privilege, but that's never happened so far, and the circumstances in which that could theoretically happen are extremely circumscribed. But the judge says that a special master must review all the government records to determine if Trump can raise executive privilege to shield these records. But so far, the judge has only raised this issue. We don't know what procedures, if any, the special master will have to follow when one is appointed. So let's talk about what it means to appoint a special master. Normally, a special master would help the court sift through materials that may be subject to attorney-client privilege. Now, someone is going to screen these records for attorney-client privilege and presumably executive privilege. But that's sort of up in the air. Federal courts haven't developed case law about when an ex-president can assert executive privilege, so the special master is not going to have any guidance based on the case law itself. But presumably we'll get more guidance from the court when it issues its final order actually appointing the special master. And there is another complication that goes unaddressed by the judge. Here, the PRA requires a dispute over presidential records to be handled in the U.S. District Court in Washington, D.C. 44 U.S.C. Section 2204 states, quote, "The United States District Court for the District of Columbia shall have jurisdiction over any action initiated by the former president asserting that a determination made by the archivist violates the former president's constitutional rights or privileges." Here, Judge Cannon, in her order, said she recognizes that this is the law of the PRA, but she doesn't say how the special master's appointment can be squared with Section 2204. If she admits that Section 2204 applies, then why would a special master appointed in the Southern District of Florida have any power? Why does her particular civil court case have any power in the Southern District of Florida? So what happens next? Well, now the parties must meet and confer about who might serve as a special master. Ideally, they would agree on a list of names, but that's almost certainly not going to happen here. Keep in mind that this order only applies to evidence seized on August 8th. It actually doesn't apply to an earlier subset of documents that Trump sent to NARA or the boxes of records that his lawyers gave to the New York City DA, Alvin Bragg. And while many attorneys have rightfully criticized Judge Cannon's order here, we'll really get a window into whether she's just trying to bend over backwards to provide fairness to a former president in a politically charged atmosphere, or whether she's in the bag for Trump based on who she appoints as the special master. And on Thursday, the Department of Justice officially filed a notice of appeal with Judge Cannon and a motion for partial stay of her order regarding the special master pending that appeal. Now, the notice of appeal is just a placeholder. It's just a paragraph that you file with the court that says they will appeal the September 5th special master order and the injunction. But the motion for partial stay has more detail. The government, quote, "seeks to stay to the extent that the order enjoins the further review and use for criminal investigative purposes of records bearing classification markings that were recovered pursuant to a court-authorized search warrant and requires the government to disclose those classified records to a special master for review." Now, the DOJ says that it disagrees with the court's decision to appoint a special master over the materials, but it's only seeking an immediate relief over a subset of those records, the ones marked classified, because those aspects of the order will cause the most immediate and serious harms to the government and the public. The classified records, a discrete set of just over 100 documents, have already been segregated from the other seized records and are being maintained separately. Now, the Department of Justice argues the classified records are also not personal to the plaintiff, former President Trump, and would not reveal any sensitive personal information. The Justice Department took issue with the judge's conclusion that as of right now, it isn't possible to determine which records Trump might own, saying that the classified government records are easily identifiable by their markings, are already segregated from the other seized records, and do not include personal records or potentially privileged communications with his personal attorneys. In other words, the DOJ has already done its review. The government disagreed, as expected, with the judge's interpretation of executive privilege and the Nixon versus GSA case. And the DOJ has a bone to pick with Judge Cannon over her reliance on a concurrence by Justice Kavanaugh in the case of Trump versus Thompson. The DOJ argued, quote, "Thompson involved a claim of executive privilege by a plaintiff as to records sought by a congressional committee, which means that he wanted to stop dissemination of the privileged materials outside of the executive branch." And that makes a little bit of sense. In the possible theoretical places where a former president could exert executive privilege, it would probably be against a third party, not the executive branch itself. And the DOJ argued that, quote, "Neither the Supreme Court's opinion and Kavanaugh's concurring statement concluded that an ex-president can successfully assert executive privilege to prevent the executive branch itself from reviewing and using its own records." The DOJ also argued it didn't make any sense that part of the executive branch could continue its review and part of the executive branch could not. But this appeal is a risky move. It could lead to a delay that could take longer than complying with the special master procedures, and they could also lose the appeal because the 11th Circuit is going to 11th Circuit and generate unfavorable precedent. And in a minute order, the court asked both parties to respond to the DOJ's motion, and it gave Trump until September 12th to file his response. Now, some see this as the beginning of the judge walking back from her extreme position before getting hammered on appeal, but she may also just be crossing T's and dotting I's. But you'll be able to read all about Trump's circumvention of all rational laws in today's sponsor, Morning Brew, because that's my favorite way to catch up with pop culture and the news. I've actually been subscribed to Morning Brew for forever. It's one of my absolute favorite newsletters, and I'm really thrilled to tell you why. Because Morning Brew, if you didn't already know, it's a free daily newsletter delivered Monday through Sunday. It gets you up to speed on business, finance, tech, and law in just 5 minutes. It provides a fantastic quick summary of the most important issues, all while being witty, irreverent, informative, and fun. And did I mention it's completely free? This week I read all about the passing of the Queen, the UK's new Prime Minister, NASA's new space launch Artemis, Missouri bringing back spanking to its schools, and someone who sailed 40 miles in an 861-pound pumpkin. It's basically exactly the mix of news that I'm actually interested in, and the stuff that I didn't even know I wanted to know about. And it's all written in a hilarious style. Morning Brew is one of the few emails that I actually open every single day. So Legal Eagles, this one is a complete no-brainer. Morning Brew is completely free and it takes less than 15 seconds to subscribe. Just click on the link that's on screen right now or in the description to get Morning Brew for free. And not only will you get a newsletter that you'll actually read, you'll actually help out this channel too. So click on the link below to get Morning Brew right away. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.